Hi, I'm Carrie Felice, Probate Department Chair with Elder Needs Law. May a personal representative sell real property of an estate, and if so, how? Well, if you have recently lost a loved one who owned real property other than their homestead, you may be wondering how the personal representative of their estate would go about selling the real property to satisfy creditor claims or to divide proceeds between the beneficiaries. Well, if your loved one had a will, it might give the personal representative the power to sell a specific piece of real property. Something like, I direct that my property located at 123 Main Street be sold and the proceeds divided between Bob and Mary. Or their will may just have a power of sale clause included within the list of powers given to the personal representative. In either of those cases, a separate order from the court allowing for the sale is not necessary. In addition, if the will directs that the property be given to a specific beneficiary, such as I give my property located at 123 Main Street to Bob, then the personal representative may execute a personal representative's deed to convey that property directly to Bob. But it's important to note that if the PR will be selling the property, the personal representative has a fiduciary duty to the beneficiaries of the estate to get a good price for the property. Now, if your loved one did not have a will, an order from the court will be required to sell any property that they owned. The court must find that it is in the best interest of the estate and for those interested in the estate that the real property be sold. Oftentimes, where there are no liquid assets in the estate, real property must be sold to satisfy creditor claims, estate expenses, funeral expenses, or even specific gifts in the will, like I leave Susie $1,500. So there are lots of cases where it would be in the best interest of the estate to sell non-homestead real property. Now, the personal representative, whether by virtue of the will or the court order, will have all the authority necessary to sell the real property. They can sign the listing agreement with the real estate agent. They can sign the real estate contract. They can sign all the closing documents. And then the proceeds from the closing would then be transferred to the estate's bank account for distribution by the personal representative as the estate progresses. Now, if you have recently lost a loved one and would like to speak to a probate attorney about the administration of their estate, please call us today and schedule a consultation. We would be happy to assist you through this difficult time. Thank you.